2nd of this year marks the third phase of some major changes to our auto no-fault law, courtesy of the law passed, of course, back 2 years ago in 2019. One area that'll be significantly changed is family-provided attendant care. Here to break it all down for us, attorney Tom Sinus of Sinus Dramus Law Firm, joining us like he does every weekend. Tom, first of all, what is attendant care, and what was the law for accident victims before the change back in 2019?
It's a great place to start. As you correctly point out, we had a change in law in 2019, and we are phasing in various parts of that change. But we have to go back to that for reference to where we are now. So before 2019, and for the better part of 40 years, an auto accident victim could receive attendant care. Well, what's attendant care? Well, simply put, it's care typically provided in the person's home. And you can imagine that there's a lot of various needs that people have for in-home care. And under the old law, people had the right to choose their care providers, and their care providers could be paid a reasonable charge for the services rendered. And what was significant, of course, is that those care providers could be family members. So if a parent had a catastrophically injured child, as tragically has happened, the parent could be the caregiver for the child, and the parent could be paid a reasonable charge for the services rendered to the child. And of course, that's significant because it allowed people to keep the care within their family and not have to bring in strangers to the home to provide that care to a loved one. Now, that, of course, is about to change significantly, and we can talk about that next.
Yeah, let's go right there. What is happening this year? Like you said, July 2nd is what we touched on. What is happening and how it will affect accident victims and their family members?
Very big change after July 1, so on July 2. What's going to happen then? Well, the law that was passed in 2019 says that family members cannot be compensated for more than 8 hours a day of care rendered to another family member or somebody else with whom they live, even if they, in fact, render more than 8 hours a day of care. So if someone needs 16 hours a day of care and that's been provided by their family member, after July 1, the no-fault insurance company is not obligated to pay the care provider more than 8 hours a day. There is an option where the no-fault insurer can choose to contract with the family member for more than 8 hours a day, but they do not have to. And one of the things that's particularly challenging, and in full disclosure, our law firm has filed a lawsuit challenging the constitutionality of this, but one of the things that's particularly challenging is that these changes are being held to apply, they're being made to apply to people who were injured before these no-fault reforms were passed. And the reason it's significant is because there are a number of families that have built their life around the idea that they can care for their loved ones and be compensated for that. And now all of a sudden on July 2nd of this year, many of them will be in the situation where they're not paid for more than 8 hours a day.
Wow, that's like kind of the opposite of being grandfathered in is what we usually say, things like that. Wow.
Sure.
That's a tough one. Where do people track you down, Tom? A really touchy subject. Where can they get you?
Well, they can find us online at www.sinusdramus.com and give us a call in West Michigan at 616-301-3333 or shoot us an email at info@sinusdramus.com.
All right. As always, important, good stuff. Thanks, Tom.